I call Chris Bishop.
Thank you, Mr Speaker. This is a very important piece of legislation, and people listening on the radio or watching it on parliamentary TV this afternoon may not appreciate the significance of the codification of the Evidence Act in 2006, which drew together various strands from the common law and common law rules and various other parts of statutes and codified the law relating to evidence. And actually, evidence law is of paramount importance in our justice system and to the rule of law, because it governs the way in which things can be put before the courts in trials, and so it's of huge significance. And the Evidence Act in 2006 was a big step forward because, as I say, it did codify that, and it allowed people to go to a particular act on the statute books and identify all of the various rules and all of the various things that they had to do in trials. Of course, one might well make the criticism that it's all very well to say you can go to a particular act, but of course the terms of arts that are within that act are of course based on the common law. But notwithstanding that, it was definitely a big step forward. In fact, I was at law school in 2006 when this was going through, and we actually had to learn two pieces of law. We had to learn the formal law and then we had to learn the codified law, so it did create a few issues. But I think it was a big step forward, and it was one of the far-sighted things I think that the Parliament did in 2006 was to put in place an automatic review mechanism so that the Law Commission would do a review of the Act in 2011. And of course, the Law Commission is the very appropriate body to do such a review. With something that's so technical but so important, you want the experts in the field, which of course the Law Commission, or at least they have access to the experts and the time and the resources to consider something intensively and in a proper and appropriate fashion. So they did the review in 2011, and then in 2013 we had their report, and then Parliament acted last year, or the government acted and put this bill before the Parliament. So I think the way in which the government and the Parliament has gone about reforming the law, and this is a very, it's sort of like a case study, I guess you could say, for the way in which proper, deliberative and consultative law reform should be done, and that's highly appropriate given the particular area of law that we're talking about. This is a reasonably technical bill. It's something that's very targeted at the minor but important changes that came out of the Law Commission review, and it's really great that we have, I think, unanimous support in the Parliament for passing this bill through. With something so important, you do want to have, I think, a degree of consensus in the Parliament. I just want to briefly mention the area of the admissibility of sexual experience of complainants before the court. And this is something that the New Zealand common law, in fact the New Zealand legal system, as is in the case in other countries, has struggled with for many years. And we continue to struggle with it. And some members will, of course, have seen the case of the Stanford rape case that's currently going on in the United States, and the national conversation that's going on in the United States about rape culture and the way in which the legal system over there has dealt with the victim, and also the way in which the system has dealt with the offender in that case. And the letter that the victim in that case read before the court as a sort of victim impact statement is 7,500 words of the most harrowing words you will ever want to read, and quite a shocking and quite a searing experience. So the way in which the legal system deals with rape in particular, and sexual violence and assault, needs to be improved. And I think everyone acknowledges that. And this bill goes some way towards doing that. There's an argument, and I think an argument that people make in good faith and in good conscience, that the sexual history or experience of victims should not be admissible at all. There should just be a blanket prohibition on that. Some people make that argument, and I acknowledge that argument. The position that the New Zealand law has got to is that it's admissible only when relevant, and only if not admitting it would be contrary only if admitting it would be contrary to only to exclude it would be contrary to the interests of justice. So that's the position the New Zealand law has got to. But what this bill does is introduce not so much a safeguard, but I think an improvement on the status quo by adding a requirement that the defence gives notice before they start a trial if they intend to use evidence about a victim's sexual history with someone other than the defendant. This was a change recommended by the Law Commission, came out of very important work that Yvette Tinsley and Associate Professor MacDonald from the Victoria University of Wellington Law School have done, and I think is replicated in the Victorian legal system, the state of Victoria in Australia. And so what that will mean is that the admissibility of that evidence will be determined pre-trial. So at the moment, the status quo is that it can be introduced at any time, or at least permission can be sought from the judge at any time, and that can be distressing for victims, and that can lead to some uncertainty. So at least everyone's going to be on the same page, and the trial will commence with everyone knowing whether or not that evidence will be used or not, or at least put before the court. And I think that is a step forward, and I think there's a wider debate that we need to have as a society and as a parliament about the way in which we deal with these issues. The government's doing important work in a number of different respects to do with family and sexual violence and sexual violence more generally. But I think it's an ongoing conversation that we need to have. And with those brief remarks, sir, I commend this bill to the House.
Jan Logie.